Hi, everybody. This is Kelly McKenney Golden, and I'm presenting for EDL 850. This is my Module 12 presentation for Professor G. It's on tort liability and when are educators responsible. I am just going to do the audio version because I'm actually really short and I always get cut off on the webcam, and I think that the video, the audio is going to be just as good. So just bear with me. So a little bit about tort law. It's a civil wrong committed against one person that is independent of contract. The key thing to keep in mind is safety. So schools are supposed to be safe places for learning. If an injury does occur in a school, school personnel may be liable. And schools need to be considered safe places where teachers teach and students learn. And there needs to be safety for students, and it needs to be conducive to learning. One of the things I found interesting was the idea as teachers as in loco parentis, which means that teachers are in the place of parents to supervise, instruct, and provide safety for students. So if they have any knowledge of an impending danger, they need to try to prevent that injury. And if they don't, they could possibly be liable. School personnel liability. There's intentional torts and unintentional torts. An intentional tort could be assault, battery, libel, slander, defamation. Unintentional torts are negligence. Liability can, again, result from deliberate acts or from negligence. And in intentional tort, you would require a proof of intent or willfulness, while an unintentional one, they don't actually require that proof. Just a little bit more about slander and libel. Slander is the action of a crime making a false spoken statement to damage someone's reputation, and libel is actually when it's a written statement. So I find that these are especially you want to be conscious of in schools because you want to make sure that the information that you're saying is kind of on a need-to-know basis, and that students' information is protected and teacher information and staff information is protected as well. Some other intentional torts, mental duress, false imprisonment, and trespassing on personal property. I've taken a special attention to these because some of the court cases that I have chosen to review include these three areas. So I wanted to be sure that I just gave kind of a little brief overview of those three. Now getting to our court cases. I did try to solely focus on Rhode Island cases, but I fell a couple short. So I'm going to have a combination of Rhode Island, and then my last two are going to be from other areas of the country. The first is JA versus the town of Tiverton. This involves an 8-year-old female, and it involves seizure, detention, and interrogation of a student. It was alleged the girl was carrying, quote, chemicals in her backpack. So what basically happened was that there was an 8-year-old girl. It was disclosed to a guidance counselor in the school setting that the student was carrying chemicals in her backpack. And then the girl left school on the school bus. What happened then, as the girl rode home on the school bus, the police actually stopped the school bus and intervened, and then took the girl down to the police station for questioning. What they didn't do is they never contacted her parents. So the school never contacted the parents, and the police never contacted the girl's parents after several hours of questioning. So the violations for this case were under the Fourth Amendment, search and seizure and due process. They were concerned about the mental duress, and they looked for damages and court fees. What is especially helpful in this particular case is that a settlement protocol came out of it, that if a student does need to be questioned by school staff or the police, that even if the student has left school grounds, the student will be transported back to the school and the parents would be contacted. If it took a while for the parents to be contacted, it would be for up to an hour, and then the student would be transported to the police station, but that they would continue to try to contact the parent or guardian. The next case in 2018 is JY versus the Providence School Department. And the Providence school bus strike impacted a variety, many students with disabilities, and it was a failure to honor their IEPs. So this case actually ended up being three separate suits against the school department that they combined into one. So there are three different complainants. And the biggest complaint was that they were failure to locate and timely fund transportation violated the students' free and appropriate education, that they lost educational time, that they had improper health access because the transportation that they did coordinate, some of the students needed health and nurse care, and that there was also mental distress that impacted the students. So this case actually has been settled, but there are some follow-up legalities around the way the settlement has occurred. So this is actually still pending on some levels. We have ELLs versus Woonsocket in 2016. Now, this is a little bit of a reach. It's not really a school incident, but it does involve someone who worked at a school. And I did think it was so almost really comical that I had to add it. The case basically is a profoundly deaf person was arrested and detained for making an obscene gesture. And the police department in Woonsocket was accused of failure to accommodate his disability. What had happened was Mr. Alves was accused of making obscene gestures at the police officers, and he was detained and brought down the station for questioning, but he was never provided an interpreter, and being that he was profoundly hearing impaired, he needed an interpreter to communicate. So this is a violation of his statutory and constitutional rights. And that also the police department acted with deliberate indifference to observe his rights of needing an interpreter. So this case has been settled for damages, and also what was really helpful is that the city was required to put an effective communication policy in place to serve individuals who might have hearing impairments. My first non-Rhode Island case is Home versus Manhattan Beach City in 1978. This was a neglect of supervision of students resulting in student injury. Again, with this idea that the teachers are acting as guardians, the case is basically that the student was participating in an outdoor physical education activity, and where the student was participating, there was like a rut in the ground that the student tripped on and was injured. So the family asked for both damages, and the argument was that the student had a loss of comfort and society being able to participate fully in his educational setting. And then my final case is Brianna Ackman versus Franklin Township Board of Education in New Jersey. This relates to a merry-go-round injury, and there's a couple of stipulations for this. The student was injured on the merry-go-round, and also the students were never properly advised on how to use the playground equipment appropriately. So initially this case was brought, and the argument was that the complaint was going to be barred by the Tort Claims Act. Later, the courts found that that was not the case, and that the school personnel could be liable. They were liable because, again, the students were never properly advised on how to use the playground equipment. They felt that there was a lack of supervision on the playground, and students had actually, I believe it was 8 students in total, actually had previous injuries. So due to that, the school personnel were found liable. So what can I do as a future administrator? So instead of kind of looking at each individual case and what I would do, I think overall, this is what I would do. First of all, I would be listening to staff concerns so I don't have to have reactive measures. Of course, sometimes there are going to be reactive measures, and that's just what's going to happen. Things that you don't anticipate are going to happen, and then you're going to have to put policies and procedures in place after the fact. But I think if you're always kind of listening to staff concerns, to parent concerns, to community concerns, and always trying to remain proactive, a lot of that can be decreased. Again, I think you need to be, as an administrator, you need to always be collaborate on new proactive measures as a school. So just kind of being aware of maybe where some of the school's weaknesses are and really collaborating with all the stakeholders in order to put supports in place. I would also provide support for staff with appropriate PD. So if staff have appropriate professional development um, for kind of where their liability would be, then that is always helpful. And then always reviewing new knowledge and policies frequently. So just because a staff has had PD on a topic once doesn't mean they've learned it forever. You always need to be reviewing that knowledge. And here are just some of my references for my presentation. I cited those court cases, and you can look at them more closely. And I thank everybody for my presentation. I apologize for the school bell, and I will probably see you guys again for my final presentation. Thank you so much.